Okay. Start the meeting. Good evening. I hereby call the regular meeting of the Administrative Appeals Board, February 26, 2025 to order. Board Secretary, please conduct the roll call.
Board Member Hines. Here. Board Member Hines. Here. Board Member Horn.
Here.
Vice Chair Parker. And Chair Bishop.
Here.
Thank you.
Okay, so the first item is the acceptance of the agenda. Our next item, accepting the agenda, the board can discuss and may amend the order of the agenda. I'd like to entertain a motion and a second for acceptance of the agenda. Board Secretary, please take the vote. Oh, excuse me. Sorry. Can I get a second, please? I'll second. Okay. Board Secretary, take the vote, please.
Okay, and to clarify, it's also 2 seconds. So the second by Parker, Vice Chair Parker.
Yes.
Board Member Hines. Aye. Board Member Horn.
Aye.
Vice Chair Parker.
Aye.
And Chair Bishop.
Aye.
4-0.
Okay. The next item is public comment. This time has been set aside for the members of the public to address the board on items of general interest within the subject matter jurisdiction of the board. 3 minutes will be assigned to each speaker. Although the board values your comments pursuant to the Brown Act, the board generally cannot take any action on items not listed on the posted agenda. Testimony for hearings will only be taken at the time of the hearing. Board Secretary, please begin the public comment period.
There is no further. Unmiked speakers at this time.
Thank you. Let's move to the first item on the agenda, number 4, the appeal of the administrative decision, vacation rental certificate to operate a vacation rental for the property located at 1322 South Farrell Drive, Palm Springs, pursuant to Palm Springs Municipal Code 5.25.09. Board Secretary, please ensure that the city staff and the appellant understand that their testimony is under oath.
We do have signed affidavits from city staff and appellant. If there's anyone on Zoom who desires to testify under this appeal hearing, under the laws of perjury, if you choose to speak, you hereby accept and acknowledge that your testimony shall be the truth, the whole truth, and nothing but the truth.
Okay. Can we get the city staff to please present their?
Yes, good evening. Thank you, Chair, Vice Chair, board members, city staff, and participants joining us this evening. My name is Patrick Clifford with the Department of Special Program Compliance, and we oversee the vacation rental program here in the city of Palm Springs. I do apologize that I'm not able to attend you in person. I am off-site in Austin this evening. So if there's any sound issues, feel free to interrupt me as well. We have our code supervisor, Nab Han, there to also assist if there's any breakup in the technology. Before you this evening is a staff report for the property located at 1322 South Farrell Drive. And particularly with this staff report this evening, it's related to a permit denial pursuant to 5.25090B. Some background on the ordinance is that on November 28, 2022, there was a restating of the Palm Springs Municipal Code 5.25 with Ordinance 2075. However, that did not update or edit anything new with respect to the violation this evening. Ordinance 2017 in 2017, there was an ordinance also passed that stated with Palm Springs Municipal Code Chapter 5.25090 states that upon a third violation in any 12-month period, the city manager shall suspend the vacation rental certificate for a period of 2 years. And so relating to this vacation rental property located at 1322 South Farrell Drive, this property was recently registered as a vacation rental with a start date of February 2nd, 2023. The property at one point was self-managed by the owner until March 7th, 2024, where the certificate was then transferred to an agency, APEC Rentals. During the time the certificate was valid, the city received 7 complaints towards the property between the period of October 14th, 2023 and November 24th, 2024. In that same time frame, only 1 citation was issued relating to a guest violation, and that was on April 6th, 2024 for having too many vehicles at the property. Additionally, though, there was an event that led to an issuance of a 2nd and 3rd citation related to a complaint to a neighboring property at 1344 South Farrell Drive on May 12th, 2024. It was found at that time from the code officers that the properties 1344 South Farrell Drive and 1322 South Farrell Drive were operating as a compound in violation of Palm Springs Municipal Code 5.25070C, whereas advertising or renting one or more vacation rentals as part of the cluster or compound is strictly prohibited. Additionally, the guests that were staying at 1322 Farrell, there was not a contract summary that was submitted as required as part of Municipal Code 5.25070H. So with that, with the violation that occurred on April 6, 2024, with the too many vehicles at the property, and the 2 separate violations that occurred, more of an operational violations that occurred on May 15th, 2024, where one was advertising as a cluster and the other one was for failure to submit a contract summary. That totaled to the 3 violations within a 12-month period. Thus, the city manager suspended that certificate for a period of 2 years. While the citations were issued, when the owner of the property had an exclusive listening agreement with the agency APEC Rentals pursuant to Palm Springs Municipal Code 5.25050, where an agency may retain an agent for exclusive listening arrangements, that does not resolve the owner for any obligations under the provisions of this chapter. So the violations and operational violations such as the cluster and the failure to submit contract summary were issued to the owner, not the agency. So on December 12th, 2024, the Department of Special Program Compliance received an application request for the property located at 1322 South Farrell Drive via the online request form available on our vacation rental website from the new owners of the property. On January 7, 2024, the Department of Special Programs responded with information on how to register an account with the online permitting system for the vacation rentals. And that same day, staff also responded to an email that the application had been placed on hold due to a suspension at the property, which was ending June 6, 2026. At that time, the new owners began conversation with staff on the possible next steps to a resolution. We did advise that since this application was technically denied pursuant to 5.25060C, that the denial of a registration certificate for any reason may be appealed in accordance to the provisions of Chapter 2.50 of the Municipal Code, which is this Administrative Appeals Board. We did receive an appeal of the denial on January 23rd, 2025. So city staff analysis, our approach is that effective June 6, 2024, we did suspend the certificate for 2 years with an ending date of June 6, 2026. We found that the property was sold with an effective date of December 3rd, 2024. And pursuant to 5.25060, upon any change of property ownership, the registration certificate shall expire and the property shall not be used as a vacation rental until the new or successor owner is issued a vacation rental certificate for the property. The purpose of the vacation rental chapter is to establish a regulatory program for vacation rental and home share lodging with appropriate standards that regulate the vacation rental of residential properties in hopes to minimize the adverse effects of vacation rentals on surrounding residential neighborhoods and ensure that vacation rentals and home sharing are ancillary and secondary uses of one's residential property consistent with the city's zoning ordinance and to preserve the character of the neighborhoods. The vacation rental chapter provides a permitting process and imposes operational requirements consistent with the ancillary and secondary status of vacation rentals and home sharing for the purpose of minimizing the potential adverse impacts of transient uses on resident neighborhoods. As a process, staff will not issue a vacation rental certificate for a property that has been suspended due to violations where a new owner has taken possession of the property and desires to apply for a vacation rental registration certificate due to the previous impacts on the residential neighborhood. While the 2 citations issued were operational in nature, meaning not guest related, such as music and noise, Palm Springs Municipal Code 5.25090B doesn't distinguish between violations. It simply states a violation is a violation. In conclusion, staff recommends upholding the staff decision denying the application request to new owners of 1322 South Farrell Drive for a vacation rental certificate due to the suspension issued to the previous property owner. And that concludes the staff report, and I am available for any questions you may have.
Yeah, Patrick, quick question. I hear that you mentioned that the suspension was issued to the previous owners of the property. And so now, just so I'm clear that I heard it, where does the new owner go from here then? Filing an application, what is the time frame they have to wait, or will they actually be able to apply for a certificate?
Yes, thank you. So we would not accept the application for that property until the suspension period is done in June of 2026. And really it goes down to our process about making sure that any nuisances that were impacting the neighborhoods kind of diminish. And what we'll say in the office is to allow the neighborhood to have a break from any possible nuisances that the guests have caused in that 12-month period. It doesn't say that in our ordinance specifically that it carries over to the new owner. It doesn't say that it stays with the land. It just says the vacation rental certificate shall be suspended in a 2-year period. And so again, from our processes perspective, we approach it from the part where our goal is to make sure to minimize any adverse effects in the neighborhood. And 2, we want to make sure that there's no fraudulent activity, I guess you could say, and not saying that these owners are such, but there's been cases where if someone is caught doing illegal activity or they've been found in violation of suspension, they don't necessarily sell the property. They quick claim it to another family relative or the brother or sister, which it's not really changed. It's on paper, it looks like it's changing hand of ownerships, but meaning it's not really probably changing ownership like a full sale would be. So really it's staff's approach to make sure that both avenues aren't being abused. I guess you could say we're minimizing the impacts on the neighborhood and making sure there's no suspicious activity occurring as well.
Is this a policy that has carried over on other properties as well? Besides this property?
On other properties, is that what you mean? Yeah. Yep. So, we'll have realtors call the office and check on properties, and we'll say that they've been suspended, and that's just the message we communicate. So, I know one property offhand that we've communicated the same message to, which was on Chuparosa a few years back. But yes, it's the same communication from our department that if the certificate is suspended, we won't issue another one until that term is done.
Okay, thank you. Are there any questions from the board?
I have a question. Patrick, refresh my memory. The compound issue, I think, was appealed by the previous owners. That case sounds familiar.
It is familiar, but it was for the other property that cluster was appealed. So this is for 1322. I think the appeal for the cluster was for 1344.
Okay. But if I look through your report, it looks like that violation, the the violation as part of the compound was on 1344, not 1322?
Both. There was a citation issued to both properties for cluster.
Okay, okay. And I understand the process, and I just want your feedback. Are citations issued to people or to properties?
Citations are issued to people.
Because I seem to remember that we've used this phrase before, that the violation wasn't going to carry over to the property. It was the person, like I think it was a suspension, like a lifetime suspension from ever doing short-term rentals. And I think we, at the time, reassured that person that it was them and not the property, which seems to be in conflict to this situation, to this process. Do you have any
Yes, yeah, so we have two different kind of conversation points with that. And one is when someone is denied for being permanently for operating a vacation rental illegally. So that denial carries to that person, doesn't go with the property specifically. However, with our suspensions process, when we suspend a certificate, then we don't we carry that over, at least internally of our office. We carry that over until the suspension period has been reached. And so in this case, yes, we would carry the suspension over to any new prospective owners until June of 2026.
Okay, thanks for clarifying.
Patrick, just a quick question. Is there a facility on the city website to check if a property is in compliance? Or do you have to physically call the office?
No, we do post it on the website. And I know with the appellant's appeal, I read that when they went in and when they bought the house, or around the time they were purchasing the house, the website did not reflect the Farrell Drive address on the website, which is true. When I don't know if it came up when in conversation when I was talking to the property owners or their agent, or if it was when I read the email or the appeal. I think it was in conversation. What I found out that our records, where we have most of our suspensions listed, or at least all of them listed, it didn't have that property listed. And then really looking at if it was a technical issue with our SharePoint that we use in the system, where if it didn't update correctly because it was offline versus online. But the bottom line is it wasn't on our main log that we had the property listed as suspended, so it didn't carry over to the website when we updated the website. And so when I found out that it wasn't on the website, I did have to go back and recreate a whole new database to make sure it was relevant, which is now updated at least until our latest suspension, which was back in January when I updated it last. So, but it's absolutely true. It wasn't on the website. For reference, it does list street names. It doesn't give specific addresses. It just gives street names, but I don't think there was a Farrell there at that point as well. But yes, so some will you look at the website, and we do get calls in the office.
Okay, because what would tip off a prospective buyer? Otherwise, if the disclosure is specifically if the seller's lying or on their disclosure form.
Yeah, that's actually correct. And I don't know if the disclosures, I think they might state vacation rentals. I know when we do have a real estate disclosure that's supposed to be given out to new owners of a property in Palm Springs that's supposed to sign as well. I don't know if that's given out. That's realtor documents as well. But yes, with the two main sources, we do list suspended properties on our website. And then if they didn't look at the website, they would call. If they didn't do either, they might not know to call. But yeah, the two sources that we have would be the website and the phone call.
And just one last question, in that particular neighborhood, are they over the 20% or?
They
is
are.
it- They're not over, okay, thank you.
Hi, Patrick. I have to tell you, I am troubled by this situation and by these facts. Because as I understand it, the sole grounds for denying the certificate to these appellants was the existence of a suspension that was issued to the prior owners who didn't disclose it to the buyers, who, and sort of inconsistent with the idea that, well, I'll cut to the chase. Where in the ordinance does it provide that that a buyer of a property inherits, as it were, the suspension of a short-term rental certificate?
Yes, that's a great question. So there's nothing specifically in the ordinance stating that carries over to the new owners, right? And this is really one of the first appeals that we've had of such denial. So we were really excited about the conversation that would come forward with this. But yes, there's nothing in the ordinance that states that a suspension carries over to the new owners. As I mentioned, the approach that we've taken in the office is with the goal to minimize adverse impacts in the residential neighborhood.
Okay, and as far as you know, there are no potential, known adverse impacts on the neighborhood in this particular case, right? There's nothing, these are perfectly fine new owners who would otherwise qualify for a certificate, as far as you know.
As far as I know, the new owners that have conversations, they've been pleasant, and I have not had any concern conversations with them. Like I mentioned in the staff report, really the guest impact to the neighborhood that was a verified violation was vehicles. The other two citations that were issued was more operational, where it doesn't really impact a neighbor. Again, those operationals might impact the neighbors by the calls that we received, but those were never found to have violations. So when we look at it, just like what citations were issued at the property specifically, there was the one guest kind of nuisance, which was the vehicles, and the two operational violations.
Okay, so who gets to decide, who decided that your department has discretion, or that your department can deny a new owner a certificate based on a previous owner's suspension? Who made that decision?
Yeah, truthfully, I would have to point to our previous directors, not current, that formed the department. That decision process was made around that time and is carried forward to today's. I don't know if that was before them that kind of same process was in place with respect to suspensions, a little bit before my time and maybe theirs as well. So I can't say if it carried over. But when I started with the city in 2017 as an enforcement officer, suspensions were carrying over at that time as well.
Well,
So
on one occasion, it sounds like, and
yeah.
right before this.
Oh, no, apologize. No, we've had multiple suspensions that we have talked to inquiring about where we say we wouldn't issue a new certificate. So not just one occasion, one offhand that I recall, but there's been a handful, I guess. I don't have a specific number, but we do have realtors that call in for, in fact, just talking about Farrell, there's another property on our Farrell Street that we've had inquiries about that we've said is suspended, and we wouldn't issue a permit until that is resolved.
Okay, thank you. And one last question. Do you think it's fair to deny these new owners a registration certificate when they have purchased a home in reliance on the existing ordinance and their understanding that they would be able to receive a short-term rental registration certificate? Do you think that's fair?
Well, I think that's the reason why we wanted to bring this to the appeals board to get their guidance. As an administrative and enforcement staff, we aim to enforce the ordinance, what is given to us. So we don't really kind of go into situations thinking if this is fair or if this is not fair. We follow the ordinance to how we apply it, and if they are there's a grievance towards our decision, we follow the appropriate staff or appropriate process to give them to the appeals board for that conversation.
Okay, and I appreciate that. But you're not enforcing the ordinance when you take the position in my opinion, you're not enforcing the ordinance, because there's nothing in the ordinance. That that says that the new owner of a property previously suspended by a former owner is barred from getting a certificate. We'll talk about that as a board, but your knowledge, has this board ever considered this question before?
To my knowledge, we've never brought forward a denial for a suspension, not that I recall at all.
Thank you.
Okay, any other questions? Okay. At this time, I would like to open the appeal hearing. The appellant is invited to speak up for up to 10 minutes. Any members of the public who desire to speak on this appeal hearing shall have up to 3 minutes to speak. If any member of the public does testify, the appellant will be invited to provide a rebuttal for up to additional 2 minutes. So at this time, is the appellant here? Oh, great. Could you come on up, please? And if you wouldn't mind just pressing your button and yes. And then just give us your name, please.
Pauline Gadikian,
Thank you.
and I think my husband is on Zoom.
Okay,
Is it on?
yeah, just press the button. If it's green, it's on.
Okay.
Okay, so you can start your 10 minutes now.
Okay. Good afternoon, members of the Administrative Appeals Board. Thank you for your time and for allowing me to speak today. My name is Alan Gadikian, and I'm here with my husband, Steve Gadikian, who's joining via Zoom. We are the owners of 1322 South Farrell Drive, and we are appealing the denial of our vacation rental certificate. We purchased this home in December 2024 with the intent to use it as a vacation home for our family and to operate a short-term rental when we're not occupying it. Like many homeowners in Palm Springs, we plan to offset the significant costs of ownership through a properly licensed and compliant short-term rental. We fully support the city's vacation rental regulations and its efforts to enforce compliance. However, in this case, we are being unfairly penalized for violations that occurred before we owned the property. Violations that we had no way of knowing about, despite doing everything a reasonable buyer would do to confirm the property's rental eligibility. When we purchased this home, we relied on multiple sources to verify its status as an active vacation rental. The home was marketed as one in the MLS listing, with the seller's agent confirming it was actively rented. The sellers themselves marked no on their legally binding disclosures forms when asked whether the property had any citations, notices of abatement, or governmental restrictions. The city of Palm Springs maintains a public list of suspended vacation rental properties, and our address was not listed. Our property manager even contacted the city to confirm rental eligibility before closing, and no mention of a suspension was made. To further reinforce the impression that the home was in good standing, the prior owner left the vacation rental certificate visibly displayed inside the home. It was only after closing, when we submitted our application for a new certificate, that we were informed the property had been suspended for 2 years due to 3 violations by the prior owner. At no point during our due diligence were we made aware of this. If the sellers had been transparent, or if the city had properly disclosed this suspension, we would not have purchased this home. Now we are facing a significant financial hardship for actions we had no involvement in and no opportunity to prevent or correct. The staff report recommending denial of our appeal states that Palm Springs Municipal Code requires a 2-year suspension after 3 violations. We do not dispute that the prior owner received these violations, but the code does not explicitly state that a new owner must inherit this penalty. The intent of this rule is to hold bad actors accountable, not to punish responsible new owners who purchased in good faith. The city has the authority to exercise discretion in this manner, and we believe that it is the fair and reasonable thing to do. We have been damaged as a result of the city's flawed system of reporting violations and punitive decision to not overturn the suspension in light of flawed transparency within the city and no way for the public to know if any license is valid. In the event it is not overturned and the city does not take responsibility for correcting the poor management of the vacation rental program, I will take up cause and make sure that it is brought to light and all those unwilling to take responsibility be held accountable for their poor public stewardship. We understand the importance of regulating short-term rentals and we want to comply with all city requirements. But applying the suspension to us, new owners with no connection to the prior violations, goes against the intent of the ordinance and creates an unfair burden. We are not the problem the vacation rental regulations were designed to address. We are responsible homeowners who want to follow the rules. For these reasons, we respectfully ask that the board remove the suspension and approve our application for a new vacation rental certificate under standard conditions without additional restrictions or heightened scrutiny due to the prior owner's actions. We also humbly request that our appeal fee be refunded as we had no involvement in the violations that led to this situation. And this appeal would not have been necessary if the information had been disclosed before we purchased the home. We also ask that the city consider revising its policies to ensure that home buyers are made aware of rental suspensions before they purchase the property, so that no one else is put in this position. We are simply asking for fairness. We did everything right, yet we are now facing consequences for another owner's actions. This is an unintended consequence of the city's vacation rental rules, and we believe you have the discretion to correct it today. We understand the importance of the city's vacation rental regulations and want to work within them. However, we are concerned that denying our appeal not only creates financial hardship for us, but also raises larger transparency issues for future buyers. If the city is going to enforce rental suspensions against new owners, they need to provide reliable and current information so that buyers can make an informed purchase decision. Otherwise, this creates a consumer protection issue that could lead to further challenges, both legally and from other homeowners who may face similar problems. We strongly urge the board to consider this when making its decision today. We sincerely hope you will grant this request. Thank you.
Thank you. Are you finished?
Unless my husband needs to chime in.
No, I think we're very grateful for the opportunity to be able to present our case. It was a very big surprise to us to find out about this, and unfortunately, the other seller appears to have deliberately concealed this information from us. And we tried whatever we could to be informed buyers about this, and it's really unfortunate that we're all in this situation together. But we really hope that you guys see the unique circumstances here and help us find a way forward.
Thank you. Board Secretary, are there any public commenters?
We have a gentleman online, however, who did not request to speak, he did not register. It's up to the board whether you'd want to accept his public comment. I'm not sure if it's even in regards to this item.
Could I, Ace, would you mind answering that for us, please?
Chair, at this time it would be appropriate if there's any questions for the appellant, otherwise, they would step back and we would have a question.
Okay, all right. Board members, if there's any questions.
I have some. Hi, thanks for joining us today.
Thank you.
I see all your documentation and kudos to you guys for providing all of this detailed information. I just want to hear it from you on record that the seller did not disclose to you the suspension,
No,
correct?
they did not.
Thank you. And did you guys buy 1344 also?
No.
Just this one, 1322?
Yeah.
Okay, thank you. I don't have any other thing.
Any other questions from the board?
I'm just curious, have you been in touch with the sellers since?
Yes, once we found out that the suspension was in place, we sent certified letters to the seller and the seller's agent. We did not get a response.
Yeah.
That was my only question.
Yeah.
Thanks.
Okay. Any other questions from the board? Okay, now we can ask for public comment.
Mr. Holby, did you have comments in relation to this item? You'll have to unmute if you do. Mr. Holby, did you have comments?
He's muted.
Yeah, he has to unmute. Thanks.
Sorry, Mr. Hoban's not here. I think maybe when I signed in, it's coming up as his name. I don't have any comments.
Thank you.
Okay, so we will now close the public hearing. And next, I'd like to open up discussion for the board if there are any additional questions.
I think I'm sort of going where you were in your questioning, this feels, that the buyers of this property were put in an awkward situation, and yet they did everything right. They followed the, sorry, they read the disclosures. The seller did not disclose the suspension, and I think it's called out in several parts of the disclosure where that could have happened. It didn't happen. They checked with the city that went onto the website, didn't see a Farrell address. And I think in good faith went ahead and purchased the property, not realizing that this was in existence. So this feels, this doesn't feel right for them, in my opinion.
Feels onerous.
Well, I think that would be grounds. I agree that the appellant's due diligence and everything they did to try to determine the status of the property would be in itself grounds to reverse the citation. But I would go further and say that despite this being a process or a policy in place at the department for some time, that the suspension somehow follow the property and not the person, which is the first time I've ever heard that theory. I respectfully suggest that that is not anywhere in the ordinance, and that it is a flawed process. I don't know whether I have anything more to say about that, except, and I will defer to counsel on the legal point, but I am pretty enthusiastically going to reverse that citation.
Board member, would you like me to advise the board on my interpretation of the ordinance?
Yes, I'd love to hear what you think.
Yeah, so as I read the ordinance, I don't believe that it applies here. The provisions that are cited by staff, I would make key points that the board should consider. First off, section 5.25.060C, which relates to the third which is a provision that relates to the issuance of a vacation rental certificate. It provides that a vacation rental registration certificate shall be denied a registration certificate for the same unit and issued to the same owner has been previously revoked. So that provision clearly contemplates that only applies to the same owner. Likewise, the following provision in that same section also indicates that the ordinance was not intended to apply in this manner. That provides that upon change of property ownership, the registration certificate shall expire and the property shall not be used as a vacation rental until the new or successor owner is issued a vacation registration certificate for the property. This section, typically when we are conducting interpretations of statutes, ordinances, the such, we would not read language that would, in a manner that would render it ineffective. And interpreting even a revocation, which is actually a higher penalty, this way would clearly contradict that, right? If the ordinance were intended such that an owner cannot receive a certificate for property that had their vacation rental certificate revoked for the previous owner, then this language would be unnecessary. It would render this unnecessary, and so that's that. The final point I will make is that I also do not read section 5.25.090B to be applicable here. That does relate to the third violation, which resulted in a suspension, but likewise that provision says upon the third violation in any 12-month period, the city manager shall suspend the vacation registration certificate for 2 years. Notwithstanding the preceding sentence failure, but any person who is responsible to remit to the city's transient occupancy tax pursuant to chapter 3.24, following written notice to do so, shall result in a suspension for 12 months of that person's vacation registration certificate for the applicable property. which also indicates that this provision is meant to apply to that person. Now, I understand that there are concerns with potential fraud that could be involved with respect to instances in which there may be individuals acting in concert to contravene these provisions. I will not at this time advise on whether the city could apply these provisions in that manner, where there is evidence that that's what's happening. I think that the city may be able to still do so in that regard. However, the board should consider whether that's the case here. If that is not the case, I don't believe that the provision cited in the staff report by staff would apply, and that I don't believe that there is a valid basis under the ordinance to that would support this denial based on the suspension. The final point I will make is that the ordinance does allow the city manager to adopt administrative regulations to interpret this. And so if there is further concern by staff about how these provisions are being interpreted, the staff has a manner by which to adopt regulations that address it. Of course, those regulations cannot clearly contradict the ordinance, but the city staff does have an avenue for adopting those types of policies and procedures in a formal manner such that individual property owners are put on notice that these are existing requirements.
Thank you. One last question for you, council, and that is, does this board have jurisdiction to refund the fee that is payable upon notice of appeal?
The board does not have that jurisdiction. That's not one of the remedies that the board can take. That's something that the property owner, the appellant will need. If the board is to overturn this denial, that is an issue that the appellant will need to raise with staff. But that's not something that the board is able to do. What the board is empowered to do is simply to uphold or overturn the denial.
Maybe we can ask the city staff, because I thought that happened automatically. I thought if something was overturned, the appeal fee was reversed. Is that not the case?
That is the case. Yes, we will refund the.
Okay, thank you. I thought so.
Okay, any other questions? So shall we talk among ourselves? I think we're all probably on the same page.
No, I think if I were in the same position, I'd be sitting before you guys as well. Once I saw once I saw the disclosure by the seller, it was in my mind pretty clear.
Right, and I have to agree also with a comment from the board member that it was kind of a surprise. I always thought the violation went with the property owner. And in this case, I think it's unfair. So in total agreement with the rest of the board in regards to this issue not being valid.
And I guess I would only suggest to the appellant that to the extent that you've been damaged further, notwithstanding more than just the fee you paid to be here today. I hope you get some kind of response from the sellers, because I'm sorry they treated you that way. And welcome to Palm Springs.
It's a great city.
Okay.
That's all I have.
So can I, any other questions?
I have one more question for council, sorry. Just following up on what a board member Hein was talking about earlier with regard to the verbiage of the code. So I think it's your position, and based on her concerns, which I agree with, you don't recommend a rewording of the code. It just needs to be applied in the way that was probably intended. Am I putting words in your mouth, or did I say that correctly?
Yeah, so I think this simply just relates to my role. I act as counsel to the board, so my role is to advise you on how to properly interpret the code. So I do not advise staff in any capacity, and I don't, I independently advise you on the code, which is why there are often times in which I disagree with staff's interpretation of the ordinance, and of course there are times in which I agree. My comments were simply intended to relate to the board that I disagree with the interpretation from a legal perspective. I don't think that the provisions of the ordinance apply in a manner that would actually call for denial in this instance. And that would be a valid basis for the board to overturn if you agree with that, with my interpretation. Whether the board wants to make recommendations to clean up language or otherwise, that's something for the board to consider. You know, either in connection with the ongoing subcommittee or otherwise. I do see that there is some ambiguity. There's some potential for ambiguity in the ordinance just because of the fact that it doesn't address suspensions and it doesn't address, for example, these instances, the concern in which staff expressed that there could be malicious owners who act in concert to try to purposely get around these violations. And so I see that there may be that the board may have a basis for wanting to suggest difference in language or additional language to clarify that. But what I can advise on right now is that the language as it exists in the code as of right now and the administrative regulations, I do not believe supports staff's denial of the application.
Thank you for clarifying.
I move that we overturn the denial.
I was just gonna put a motion out there, so go ahead.
I move that we overturn the denial.
Okay, can I get a second?
Second.
Okay, motion carries to, so,
No, she needs to
We have to
vote.
vote.
yep, so can we get a vote, please?
Board Member Hines,
Aye.
Board Member Corn.
Aye.
Vice Chair Parker,
Aye.
Chair Vasily,
Aye,
motion carries 4-0.
okay, great,
Thank you
congratulations,
very much.
thank you.
Thank you. Appreciate it.
It's run through as a legal binding.
Yeah.
I guess she does recourse.
She does.
Yeah, okay, let's move on to the next, number 5. The appeal of the administrative decision to deny vacation rental certificate to operate vacation rental for the property located at 1172 Deepak Road, Palm Springs, California. Board Secretary, please ensure that the city staff and appellant understand that their testimony is under oath.
We do have signed affidavits from city staff and appellant. Anyone on Zoom who desires to testify under this appeal hearing under the laws of perjury, if you choose to speak, you hereby accept and acknowledge that your testimony shall be the truth, the whole truth, and nothing but the truth.
Okay, city staff, would you please present your report?
Yes, good evening, Chair, Vice Chair, board members, city staff, public joining the conversation this evening. My name is Patrick Clifford with the Department of Special Program Compliance, and we oversee the vacation rental program here in the city of Palm Springs. Before you this evening is a staff report for the property located at 1172 Deepak Road here in Palm Springs. This staff report is in relation to a denial of the vacation rental certificate, more appropriately due to reasons related to Palm Springs Municipal Code 5.25045 related to the vacation rental neighborhood percentage cap. So ordinance background: on October 17th, 2022, the City of Palm Springs City Council adopted an interim urgency ordinance number 2071, which established a 45-day moratorium on the issues of new vacation rental certificates due to potentially additional regulations of the vacation rental ordinance in the city. One significant issue is decided was the scope of the temporary moratorium, in which how pending applications would apply that were in queue during the moratorium. Properties for which a permit had not been issued, but for a completed application had been received, the city council was presented options to include pausing the issuance of vacation rentals that were applied for using specific dates. So the first option was September 22, 2022, when the council agenda was originally posted, but the council did adopt the date October 17th, 2022, which was the date of the effective moratorium. So that date of October 17, 2022 does play a significant part in the reason the permit or the certificate was denied. But at that time, the city council directed staff to use the October 17, 2022 as the effective date of the moratorium, and that no new certificate would be approved or issued. On November 28th, 2022, the city council adopted ordinance 2075, which terminated the moratorium that was adopted on October 17th and restated the Palm Springs Municipal Code 5.25. The ordinance did introduce a few more definitions, one with respect to what a new permittee was and what an existing permittee was. And so with a new permittee, the ordinance defines a new permittee as a property for which a complete application for a vacation rental registration certificate was filed with the city after October 17, 2022. And an existing permittee is for a property for which a vacation rental registration certificate had been issued or for which a complete application had been filed with the city on or before October 17, 2022. Additionally, ordinance 2075 established a cap on the number of vacation rental registration certificates that can be issued, which is based on a percentage of those certificates that are issued in a particular neighborhood in relation to the total number of dwelling units within that neighborhood. Additionally, the neighborhood-based caps would not affect any existing certificates that had already been issued by the city, even in neighborhoods that exceeded the percentage cap. So some background on the application in question in the staff report. So on October 3rd, 2022, the Department of Special Program Compliance received an application for the property 1172 Deepak Road on behalf of Adam Gilbert from Kevin Francis, a local property manager. On October 3rd, that same day, Special Program Compliance staff sent an email to the property manager asking for missing documents before processing could occur. These documents were a proof of insurance, a file stamped grant deed, and the pool inspection invoice. On October 14th, 2022, Special Program Compliance staff received an email from the property manager resolving the missing insurance document that was requested on October 3rd, 2022. During the period between October 3rd, 2022 and October 27th, 2022, Special Program Compliance staff conducted title searches to verify if the official county file stamp grant deed was accessible. And it wasn't until October 27th, 2022, that staff internally was able to print the missing file stamp grant deed on behalf of the applicants, thus completing the application. The date of the recording of the grant deed, though, was October 12th, 2022. So the county recorded it on October 12th, 2022. On October 27th, 2022, it was confirmed that the missing insurance and pool certification invoice documents had been received by staff, and staff added the file stamped grant deed to the application material, date stamping the application as received October 27th, 2022. On January 23rd, 2023, the application was rejected and returned to the owner via certified mail and email. And the rejection letter also included a wait list application, and that is provided to you in the staff report as attachment 4. On June 6th, 2023, the Special Program Compliance staff received a completed wait list application for the owner of record for the property 1172 Deepak Road. On August 28th, 2023, the Department of Special Program Compliance staff mailed and emailed a letter regarding the appeals process available to owners whose applications were not accepted or was impacted by the moratorium and the newly adopted regulations. And that's available in the staff report as attachment 5. As mentioned in this letter on August 28, 2023, there was discussion to bring exemption requests to the City Council for review and approval. Exemption requests included, but not limited to, properties that were under construction during the ordinance proceedings and properties that were in escrow. However, the city chose not to take exemption requests to the City Council, but rather accept appeal requests pursuant to Palm Springs Municipal Code Chapter 2.5 of the Administrative Appeals Board. This appeal, however, was received close to a year later on July 2nd, 2024. for the property located at 1172 Depot Road. So our analysis is that the vacation rental application was received complete on October 27th, 2022, 10 days after the date selected by City Council on which applicants would be considered new and be affected by the moratorium, and which applicants would be considered existing, which staff could continue processing under the then ordinance in effect, Ordinance 1918. The property located at 1172 Deepak Road is in the Movie Colony East neighborhood. And at the time of the application rejection, the vacation rental percentage for Movie Colony East was 23.45%, with 6 persons on the waiting list, and that's attachment 6. As of February 6, 2025, the Movie Colony East is at a 19.78% percentage, with 24 applicants on the waiting list. The neighborhood has 147 vacation rentals and 743 residential units. With 743 residential units, the maximum number of vacation rental certificates that can be issued in the Movie Colony East neighborhood is 148. In the event that a VR percentage cap has been exceeded for a particular neighborhood and additional complete applications were on file with the city for vacation rental registration certificates, we would issue those certificates if the percentage dropped below 20% in a first come, first right basis based off the wait list. Now, the current owner of 1172 Depot Road is number 8 on such waiting list. Staff recognizes that during the ordinance proceedings with City Council, there were conversations regarding how to administer applicants who had submitted completed applications in the vacation rental work queue, and regarding prospective applicants that were currently in remodel construction phase of their property or in escrow that's not able to apply before the October 17, 2022. But no formalized path was decided, rather only that completed application received on or before October 7, 2022 would be considered existing permittees who would not be affected by the newly adopted rules with respect to neighborhood cap limitations. So in conclusion, staff is recommending upholding the staff decision to deny the application for vacation rental certificate for the property located at 1172 Deepak Road due to the restrictions set forth in Palm Springs Municipal Code 5.25045, caps on certificates based on neighborhoods. Additionally, staff recommends denial the appeal pursuant to Palm Springs Municipal Code Chapter 2.50.080B, as the appeal was received outside the required 10-day and 15-day filing requirement. That concludes my staff report, and I am happy to answer any questions you may have.
Thank you. Is there any questions from the board for the city?
Yeah, I have some. Hey, Patrick, so, educate me, when an existing short-term rental sells in a neighborhood that's already at cap or over cap, does, especially if it's on the threshold, well, maybe, let me state it another way. If you have some sales that bring it below the cap, do you automatically go to the next person on the wait list?
Yes, correct. We will treat it that it's still technically overcapped because we have X amount of numbers on the waiting list. So we would put them on the waiting list and then go with the first person on the waiting list that's eligible for a permit or a certificate. So we would call them first before accepting a new one that came into the office.
Okay, thank you. And then just following up on something that you said, and then also in your report, is my understanding correctly that the application package, when it was originally received, there was a couple things missing. I think you mentioned insurance, something, and pool inspection. And it sounded like those were received, but you were unable to get your hands on the reported deed from the county until later on that same month. It sounded like the 20 something. So the city took the position of calling that application complete when that deed was put into the file. Is that correct?
That's correct. Our staff member visited the website daily to see our title search website to get a copy of that deed because it wasn't turned in by the applicant. And so daily our staff would check to see if we can get a copy of that. And it wasn't to that date, I think I mentioned it was October 27th, that he was able to get a copy and print it and put it into the application, deeming it as a completed application.
Okay, but everything else, aside from getting a copy of the deed, which looks like it was recorded before the deadline, we just didn't have a copy of it. The rest of the application was complete by the 17th.
That's correct.
Okay, thank you.
I have a question. Patrick, was this property a vacation rental before this gentleman bought it?
It has been a vacation rental in the past, yes. I don't know if it was a vacation rental at the time of the purchase. I know we do have history as it being a vacation rental. I just don't know if it was exactly at the time of sale.
Okay, and just to quickly follow up, what is the policy if a home that is a vacation rental in an over percentage neighborhood gets sold? Shouldn't the right to rent it go to the new owner, or it goes to, no, it goes to
Next person on the
someone
list.
next person on the list?
Right.
Got it. Got it. Okay, thank you.
So Patrick, just a quick question. So when the applicant submitted his application, do you happen to know what the percentage of the cap was on what the percentage of rentals were at that time?
So at that time, the ordinance had not been passed with respect to having neighborhood caps actually part of the municipal code. I mean, there was data because in that time we were looking at numbers at that. I wouldn't say it was far off from what the denial was when we denied it in January. But at that time, the caps weren't as they weren't in enforcement at that time. The ordinance was in place. The ordinance didn't get adopted until November. So, but when the ordinance was adopted in November, that neighborhood was one of the neighborhoods that already exceeded the 20%, the cap at that time. So it immediately locked that neighborhood for any new applications coming in.
That applicant would have been put on a list anyway.
If the
Is that what
rules,
you're
yeah, if the rules were in place in October, and at that time we were considering new applications at that time, yes, if the ordinance was if those caps were in place in October, they would have been put on a wait list at that time as well.
Okay, thank you.
Hi, Patrick. Couple questions. I'm looking at this period between October 3rd of 2022 and October 27th of 2022, during which time the file accompanying the application was complete except for this file stamp, the official county file stamped grant deed. Is that right?
That's correct. That was the final document that we needed to receive to complete the application.
Okay. And you testified that so that's 24 days during which you testified at least every business day somebody from staff visited the site to print the missing file. I'm trying to understand, and I hope I'm not splitting hairs here, but we knew that that there was a grant deed on file. It just hadn't been stamped yet. I'm trying to understand the detail here and why it made a difference, why it took so long.
Yeah, of course. So the reason why we ask for the file stamp grant deed is because that will show obviously a proof of ownership, and a lot of times title search records software, for example, we use First American, they won't be most recently updated. And so the county has to then record the data and put it into their system, and then that gets communicated to First American. So that's why we really ask the applicant to provide those documents to us, so there is no delay. We never received those documents, so that's why staff was taking it upon themselves to check daily to see if we could access it to print a copy of it that's been filed from the county. So they stamp it with a record number with a date, and then we're able to search that record with our title search software and print that for them.
Did anybody from your office ever ask the applicant to supply that document, or did you said they took it on themselves to check the website?
Yeah, staff was communicating from the very first day of the documents missing. I think there was also communication that the applicant mentioned to our staff member that they did deliver it, but that wasn't the case. We never received a copy of that actual grant deed. And at that time, there was a lot of vacation rental applications coming in, especially when the moratorium talks were starting up, and we had lines out the doors. So we received the information, and then staff would communicate via email as best they could, saying, we don't have this as a completed application. This is what we're still missing. So they did that both with the insurance documents that was missing, and the pool cert, and then also the grant deed.
Any other questions?
I have a question for council.
Sure.
I believe there's been a, was this appeal filed timely under the ordinance?
Or at this time, the board should complete its questions for staff and then move on with the rest of the hearing. And if you have questions for me as to the validity of the appeal, et cetera, I'm happy to answer those during the board discussion.
Okay, I think staff has already indicated that it was not timely. Okay, we'll come back to that then. Thank you.
Okay, at this time, I'd like to open the appeal hearing. The appellant is invited to speak for up to 10 minutes. Any members of the public who desire to speak at this appeal hearing shall have up to 3 minutes to speak. If any member of the public testifies, the appellant will be invited to provide a rebuttal for up to an additional 2 minutes. Right now, is the appellant here?
I am.
Come on up. Please state your name, please.
Sure. Hello, everyone. My name is Adam Gilbert, and I'm the owner of 1172 East Deepak Strikes. Thank you for taking your time out this evening. I want to go back a little bit at the time when this occurred. It was definitely a very interesting time in the city as they were implementing the moratoriums in the various neighborhoods. I was very involved in the process of watching the council meetings and what the intent of council was at that time. And there was a group of people, myself included, who were in the process and in escrow to purchase properties that they intended to make vacation rentals as this policy was coming down the pipe for council to implement. And many council members, including Councilmember Middleton, I remember, was very clear that the people who are currently in escrow, who had spent money, removed their contingencies with the intent of having a vacation rental, would be allowed to go through that process and have their vacation rental license approved. Based on what was stated at those meetings and what I believe was the intent of council, I continued through with my transaction to purchase this property with the intent of having it be a vacation rental property. Due to timing and everything that was going on, we had, according to staff, I don't believe, I watched every single meeting, I don't believe that the October 17th deadline was ever stated by council. I think that is a staff interpretation of what they plan to do. Regardless, we continued through the transaction. I submitted my application on October 3rd. We closed on the property around that October 10th or 12th time period. And I got my close of escrow. The grantee goes to the county stamps it October 12th, and then it takes time for it to either become available to the public or get sent back to me as the owner. And so in between that time period, when we were just waiting for it to come in, that October 17th deadline passed, even though the grantee, it's clear from the stamp file that it was completed prior to that October 17th deadline. At the time when I got my denial letter saying my transaction was complete, you know, I was not very happy, and I talked to staff at the time and I said, you know, this is not the intent. The intent was if everything gets done before October 12th or October 17th, which it clearly shows that it was done on October 12th, I should be granted a permit. You know, ultimately at that time, staff did not come to the same conclusion as I did. And I was kind of put in a pickle as to what to do because at that point, I owned the home and I did not have the vacation rental permit. And so it was also a crazy time for the city. And I think there was a new city manager coming in to try and figure out how best to move through that process. And so I went through and completely remodeled the house. Spent 14 months. And just because that was really the only option that I had left at that time. And so the property that I thought I was going to get income from, I was now holding, paying a mortgage on, and now doing an expensive remodel. The house turned out great, and I'm very happy with where it is. But I think in reviewing the equity of the situation, I did everything that I could to get everything that the staff needed to get my permit, which was the intention of council at that time. And that's why I'm filing the appeal, even though it's a little later on, which I can explain about that if you have questions. But yeah, thank you very much.
Okay. Are you finished? Any other comments?
I'm all done. Thank you.
Okay, I'm gonna open up questions to the board.
I have one, Mr. Gilbert. My very first question was what you just addressed, which was why now? Why not back in 2022?
Yeah, so it was it's kind of a precarious situation in that my wife was on council at the time. In all of those discussions on city council, she had refused because we were currently in escrow on the house. But with her continuing to be in that position, we didn't feel it was appropriate to come and do an appeal to staff with her being in that position. And so now that she's no longer in that position, we are bringing forth the appeal to try to make right with that situation, with what happened.
Okay, and then sort of a follow-up to that is why go through the expense and the time and the trouble of a hefty remodel when you don't have a guarantee of a certificate of ever getting one?
The remodel was not for the intent of having it be a fancy vacation rental.
Okay.
I don't know if I still don't know to this minute if I'm going to get a vacation rental permit. That remodel was done for us, but having the option and having the intent and having the backup position of having it be a vacation rental property, what I intended to do when I purchased the property, and I think that it should be, granted.
Okay, I don't have any other questions.
Any other questions?
No.
Okay. Board secretary, is there any public comment?
No public comments at this time.
Okay, then we'll close the public hearing and we'll open up discussion among the board members. And now you can ask legal counsel a question. Thank you.
So I'll repeat my question, and that is, I had trouble understanding how this appeal was timely. And I'm wondering if I'm missing something.
Yeah, so the way that I read the requirements with respect to the period that applies for a time of appeal. What I'm wrestling with at this time, to be frank with the board, is the provisions that will apply to this appeal will be the provisions that were in effect when the denial was issued, even though the application was complete before the ordinance was adopted. Here, what I don't see in the ordinance is any clear indication that there is this time period that would apply to these applications that were received prior to the ordinance adoption. That is what I wanted to confirm again. The ordinance, which is 2075, provides that it is effective 30 days after its passage. The ordinance was passed November 2022. And so my concern here is I agree with staff that the application was deemed complete as of October 27, 2022. Because I don't see any affirmative obligation on city staff to collect portions of an application for an applicant or otherwise. The ordinance is clear that the application should be submitted in complete format by the applicant themselves. That is the case even under the ordinance 1918, which is the ordinance that would have been in effect at the time that the application was submitted. There's nothing in ordinance 2075 that indicates that it is overall as a whole retroactively applicable to applications submitted before that date. This includes the changes with respect to appeals, et cetera, any standard that is adopted under that new ordinance. Now, additionally, although the ordinance does reference existing permittees and new permittees, the only instances in which I see those terms as being referenced in the ordinance that was adopted, even if it is determined to be applicable to an application received complete before that date, is in the operational requirements. In the operational requirements, there are clear instances in which the council does differentiate between new permittees and existing permittees, such that, yeah, October 17 cutoff would apply. However, in the section relating to the vacation rental caps, I don't see any such language that relates back to existing permittees or new permittees. There's nothing distinguishing there, and there's nothing in that section that clearly applies it to existing permittees, such that that section would have such a retroactive effect. At least in the way that I see it. I also looked at the administrative regulations that relate to that the city has adopted, and I don't see any regulation that would clearly address this issue. So it's a long way of saying that it's a little bit complicated because it's unclear. What I'm trying to say is that it's unclear that the provisions of that ordinance would apply here in that respect. And so it's difficult to determine if the appeals time period is actually applicable to that instance or not.
Okay, does everybody understand that?
Yeah, actually,
Yeah, it's difficult. I'm sorry. Yeah.
But it sounds to me then what we're looking at here is a strictly legal issue. We don't really have any facts in dispute. We're not here to decide whether or not someone violated an ordinance. We're looking at procedure and
I have a follow-up question.
Go ahead.
That I think you were getting at earlier, and Abe, I'm not sure if you can answer this. Is there a statute of limitations to file an appeal? Is there a timeline according to the code? This, let's say it may not be related to a moratorium, but is there from the date someone's issued a denial letter, is there a timeline from which they can file an appeal?
So all that the ordinance says is that the provisions that will govern the appeal of denial of a registration certificate, which is here, relate to, which can be appealed under chapter 2.50, which is the general chapter that governs the Administrative Appeals Board. That is the case both under ordinance number 1918 and ordinance 2075. The reason why that issue matters is, like I said, I think there is at least some ambiguity with respect to which of the ordinances this application should be considered under. If you refer to chapter 2.50, it does designate certain filing procedures with respect to any appeal that comes before this board. And the problem with that is that it does not specifically limit the appeals time period in that manner. So you'll want to refer to subsection A, and subsection B. A person aggrieved by an action taken by an administrative officer of the city providing section 2.50.020 may appeal the action of the board by writing to the city clerk a written notice of appeal within 10 days of the action. The notice of appeal shall set forth the appellant's full name and mailing address, the specific action appealed from, the grounds for the appeal and the review sought, and shall include the payment to the city clerk of the appeal fee as established or amended from time by the resolution of the city council. Subsection B also reads, the notice required that subsection A of the section shall be filed no later than 10 days following the date of mailing to the appellant the notice of the action from which the appeal is taken. Or if there is no such mailing or none is required no later than 15 days following the date of the action, which is the subject of the appeal. The city clerk shall furnish a copy of the appeal to the respondent within 5 days after filing. Now here, if I interpret what staff has done here is that because there was no notice provided under subsection A, that the applicable time period is the 15 days, right? So it says that if there is no such mailing and or none is required no later than 15 days following the date of the action, which is the subject of the appeal. The date of the action here would be August 28, 2023. What I don't know is what the appeals process that the city staff was using at that time, and whether there was actually an appeals process that would apply in that instance. So I think I frankly think that there is some ambiguity. I think if you relate back to chapter 2.50, yes, typically there are 15 calendar days in which to submit an appeal. In that case, yes, the appeal would likely have been considered late, would be considered late and untimely. Here, the staff, of course, has entertained the appeal and proceeded with the filing of the appeal. The board, I think, can still determine whether that's timely or not. But I do think that the counterpoint to that is that it's unclear that based on the information that was provided to the appellant as to which ordinance applied, that time period for appeal would have been clearly communicated to the appellant. So.
Question. How long have you been on the board? You guys have been on the board since this time period?
I've been on for about 2 years now.
Oh, since
So,
the measure was taken.
Has
No,
this
no,
ever
since-
come up before?
No.
That anything, can we ask?
Sure.
Patrick, has this ever come up before? This missing by a week or two?
With the respect
years
to,
ago?
with respect to the application acceptance.
Yeah,
So this is the only file that I know of that we are, known of that we have this concern with or the denial with. So there were others that we emailed such same letters to regarding exceptions with respect to maybe doing remodels at their house during the time, then thus they couldn't apply, or they are in escrow at the time. Because we did receive feedback from such operator or owners. And so we emailed a letter and sent a letter out to all of those that we felt that were impacted by such timeframes, including the property owner here for Deepak. And we only received one appeal. That is the one before you this evening.
Thank you.
Interesting. Any other questions?
Questions, or are we commenting?
You can comment.
Discussion?
Is that where we are?
Yeah.
Discussion. So here's my issue. I think the appellant can always refile an application. And he'll be subject to the current rules and the current ordinance, which is apparently a lot easier to understand or administer. There was this weird time period during the moratorium that has sort of thrown everything into question. But I have, I'm concerned about three things. One is, and as council has indicated, the application was not filed and complete by the August 17th deadline. And if that's the only decision and the only fact we have to consider, then we have to uphold or the denial. Done. I think the reason, honestly, that the appellant would like us to reconsider and sort of get the benefit of the retroactive rules is because there are now neighborhood caps on the number and percentage of short-term vacation rentals in the neighborhood, and he can be denied on that basis alone, but not if he can convince us that his appeal was timely, that he met the October 17th deadline, or we shouldn't enforce it. And I'm just not comfortable dealing with all those issues. I think if there are legal issues here about any of these things, they can be considered by in his next step, but I don't think it's our function to overlook the fact that the deadline was not passed, or that the application was not timely filed in 22, and that the appeal was not timely filed in 25. That's my position.
I hear you. Totally relate to that. I have a little bit of a different opinion. I think that the appellant complied with everything that they needed to comply with by the deadline. It was just the county recorder's delay in getting the recorded deed to the city.
I understand that.
And seeing that it was recorded, the change of ownership was legally recorded on the 12th of October, clearly a week before the deadline. Everything else was complete according to what Patrick testified to in the application package. The appellant is just the victim of the county recorder, thereby falling into this sort of weird time delay. I think that he complied. I think he closed escrow before the 17th. It was his property, and thereby probably, in my view, would be subject to the neighborhood cap at the time.
Okay, okay, even though we've been advised by council that it wasn't complete, and that I mean, I'm seeing this as a question of law. What does the October 17th, was the October 17th deadline met or not? And council has told us if it was not a complete application, it didn't meet the deadline. So isn't that what you're?
I didn't hear, I'm not quite sure I heard that.
Let me clarify. I
Okay.
know that I said a lot earlier, and I think now that I've had some time to digest my own thoughts, let me clarify what I think, what my advice to you would be on this various issues that are at play here. The first issue is with respect to the date the application was completed. In my review of the ordinance, I think for a second, putting aside the issue of which ordinance applies specifically, because in that regard, with respect to the submission of the application, both of the ordinance 1918 and 2075, both of which could have been applicable to this, under deferring interpretations of the October 17th date. Those were both require complete applications be submitted by the applicant. That's the same as is the case in every other regard, right, with respect to any other city, city permit, et cetera. The requirement is that applicant seeking a permit, license, et cetera, submit the full application. Here, the only evidence the evidence that has been presented and by the appellant would suggest that complete application was not submitted until the 27th. I understand the appellant argues that that's a strict reading of the ordinance but that's simply how it is, that you cannot have a complete application with a missing component. Whether there are extenuating circumstances that resulted in that delay is not a question that is. I don't believe that there's anything in the ordinance that provides an extension or whatnot for such an instance. That's that issue. So that's the issue. I agree with essentially. I would advise the board that I do agree that October 27th it should be considered the date that the application was complete. Now, the next question, the other question that is related to that is what provisions apply once if the board agrees that the application was complete as of October 27th, whether it's the provisions that are in ordinance 2075 or not. If it's not the provisions in ordinance 2075, then it would be the provisions in ordinance 1918, which is the ordinance that was in effect before ordinance 2075. What I also confirmed following my last comments was that both ordinance 2075 and ordinance 1918 both tie appeal procedures for actions by staff on registration certificates, right, that fall under either of those ordinances back to the provisions of chapter 2.50 of the Administrative Appeals Board. Now, I previously stated that there's nothing directly in that chapter that governs this specific case. I think I was unclear on that in that regard, to be frank with the board. As I read chapter 2.50.080, that applies to any action taken by any administrative action taken by staff. And furthermore, what I confirmed now is that there was no subsequent amendment to chapter 2.50 that would during that corresponding time period. So if even if the board determines that ordinance 1918 applies, that would still fall under the same requirements for the time period for appeal. In which case, I would advise the board that I do believe that this appeal was not accepted and was not filed in a timely manner. Because it was received on July 2nd, 2024, which is more than 10 or 15 days, depending on, regardless of which provision you apply from that section, it's late. Now, I think the only other issue for the board to consider is whether the information that the appellant was given in the notice of denial all relates to 2075. However, I believe that from a legal perspective, if the appellant disagreed that is the ordinance that applied, or those are the requirements that applied, that would have itself been a basis for appeal under 1918, in which case that should have also been raised at that time as part of an appeal within that time period. So those are the two separate issues. I essentially, I agree with city staff that the date that the application was completed was October 27th. But I think that regardless of the date that the October 27th date of completion, I don't believe that the appeal was filed in a timely manner under either ordinance 1918 or ordinance 2075. So I think it's essentially a moot point whether, you know, which ordinance specifically applies and in this regard.
Thank you.
I know it's not my time, but may I comment?
No, we're finished.
Yeah.
Yeah. Any other comments?
Good. I don't think we have much choice. It was not timely filed. The appeal was not timely filed and all the rest is a mess, but the last bit is clear.
Right, thanks to the clarification. Can I get a motion, please?
I move we uphold the denial.
Second, please. I'm gonna second that. Board Secretary, can you take the vote, please?
Board Member Hein,
Aye.
Board Member Horn,
No.
Vice Chair Parker,
I'm gonna say aye based on council's feedback.
motion carries 3-1. Oh, I'm sorry. Chair Vasily.
Aye.
Motion
you.
carries 3-1.
Thank you.
You seconded.
Oh, that's right, I did it. Okay. Thank you for that clarification. So the next item is an update from the subcommittee in regard to draft recommendations to the city council regarding vacation rental ordinance. And I think legal counsel is going to give us a little bit into that.
So
Before you do, may I just comment on it? Okay, so I think I commented on last meeting. And Abe, I think you were out. I think your application. But were you here last meeting?
I was here the last
Okay, one before. Okay, sorry. So you can see in the handout specifically what we were suggesting, which I think we've gone over in detail. The one clarity that I want to make is you'll see the section on page 2, benefits to property owners with no violations. I'm sorry, this is in item 6, tab item 6 on page 2 of our memo.
Yeah. I'm good, thanks.
Okay, yeah. Page 2, benefits to property owners with no violations. What we were proposing is providing a benefit to the homeowners that do follow the rules and haven't had a violation. And so therefore, if they haven't had a violation this year, next year when the next year they would remain at 36 maximum contracts instead of, I think it drops to, Mitch, is it 24? 26. 26, okay, instead of 26. So they would get a benefit basically for following the rules. Everything else, I don't think. Right,
Yeah,
that was
we
it.
didn't. No.
Okay,
I think that's a great idea to reward good compliance and
Yeah.
good stewardship, sorry. I think that's a great idea. And so,
so the subcommittee took that, what you see, and we've sent that to Abe so that he could, I think, I may be saying this wrong, Abe, advise us on specific changes to the wording of the code based on these recommendations. So is that correctly?
that's correct. Yeah,
Okay.
my understanding is that the ad hoc subcommittee has requested that legal counsel prepare draft language for consideration. Specific code language that the ad hoc committee could present to this board for recommendation to the city council. I have not yet completed preparing that language. My intent is to prepare it and submit it to the ad hoc subcommittee first. So that it can be placed on the upcoming agenda, in which case at which time, the board can consider a formal recommendation of language or revising language.
Okay.
But at this time, this was still kept on the agenda. It's an opportunity for you all to discuss if the ad committee wants to discuss the recommendations or provide any feedback to myself, with respect to the items that the ad hoc subcommittee is proposing potential language. It will still be brought back it will still need to be brought back to the board once we have specific language. In which case the board will consider that specific language and whether it will forward it for recommendation to the city council.
Okay, great, thank you. Okay,
I think I really appreciate the time and the thoughts that you've given this. I looked at it yesterday and I really like the benefit idea, and other than that, I don't have
Okay,
really anything to add.
great, thank you. Make it as fair as possible, but also create a benefit for those people that decide to follow the rules.
I really like that idea, because we do have so many good operators and good owners.
Okay, let's move on to number 7, approve 2025 meeting schedule. So the next item 7, the portion of the meeting is set aside for the board to approve ordinance updates from the subcommittee members. Actually, we already did that, so sorry. So sorry about that. So we're gonna move on to, I think we're gonna be talking about changing the date of our meeting. 2025 meeting schedule, changing the meeting dates to the 3rd Wednesday of the month. We're gonna put that up for discussion because I believe that it was an issue with city council having a meeting on the same day. So we decided that we would look at possibly the 3rd Wednesday of the month. So bring that to the board and see if that's something that the board would want to agree on. The other thing is yeah, never mind. Just let's open up the discussion on whether or not a 3rd Wednesday of the month would work for the board members.
Do we need to remind the board why that's necessary? Was it because the city council meeting was changing
I
there?
just said that.
It wasn't conflict,
Sorry,
yes.
I didn't. I
That's okay,
apologize.
you know, we're all looking
Yeah.
down. So.
Okay.
No, it's fine with me.
I think it's fine.
You're fine.
I should probably is Evelyn?
Evelyn.
Okay, I will not be here for the April meeting.
Okay, and I have a comment on the April meeting, actually. The April meeting, was previously scheduled for a 3rd Wednesday, however, due to a Passover holiday, was rescheduled to April 23rd, however, that coincides with the council meeting day, so we have to select a new meeting date for April. So, now's your chance,
Could we skip April?
if you so choose, yes, we can, and if you want to have maybe a special meeting later at some point, if there's a need. If you'd like to explore that.
So, because if we don't, I mean, if we have this meeting, it's the 4th Wednesday, but that's when the council meeting is, right?
That's correct.
Which
You
brings-
could
brings
meet
us back to our
earlier,
Original, we'd have to meet earlier in the day.
earlier in the day or another day.
And board member Herman isn't here, but I think if I remember his comment, he can't meet earlier in the day because he works during the day. Just makes it here at this
Yeah, I
time.
think he gets off at 4.
Yeah. So what if we skip April's meeting? Oh, before we do that, Abe, do you think next board meeting in March, would it be a good time for us to check in with you on that prospective wording of the code on that, on
Yes.
item 6?
You will.
Okay,
Yes, the board will have that language. I will check with the city clerk.
Why don't
with the
we-
final
okay.
dates to submit the language, so you will be able to. consider
Okay.
language.
I move that we just skip the April meeting.
Yeah, but if there's people who have complaints, kind of not there to make them wait another month. It's a long time between.
It's a long time, except we only had 2 today, right? Sometimes we do 5 or 6, but
And August is dark anyway, so.
Right. It's fine with me. What, or you could tentatively schedule it for another day, and if there's nothing. Have tests, you can't.
What if we report back to you in March, to see how many applications
That's
we
good.
have?
Yeah,
Report
good
to
idea.
you.
Then we can decide.
As of right now,
Yeah.
there's our-
Yeah,
I mean,
that works.
I'm free and you'll be away anyhow. So,
So
Depends on
then-
the date.
yeah,
So on the schedule, I'll go ahead and notate that April is dark, unless there's a need for a special meeting, at which point we'll report back to you in March.
Great.
Thank you.
Okay,
Keep in mind, whether the meeting schedule was adopted by a motion of the board,
It
the
will,
existing schedule. If so, then I believe what would be appropriate would be for
Change the
the
word.
chair to entertain a motion to adopt a new meeting schedule, as amended, to reflect April's, as dark, and then go from there.
and also recommend the second recommendation to amend the rules of procedures of the Administrative Appeals Board.
Oh,
Section one.
From the fourth to the third Wednesday. Okay.
okay, so I will. Put a motion out there to amend the schedule. The current schedule and move it to the third Wednesday of the month. As well as recommending, what was it,
April. These dates, right?
yeah,
And
as
then-
well as recommending that we leave April 23rd or the month of April in the dark. And then also we were going to be also updating the was it the codes?
The rules of and procedures of the Administrative Appeals Board, section 1 meetings.
Thank you. So I will also recommend that as well, updating the Administrative Appeals Board Rules of Procedure, Section 1 meeting.
Chair, just for purposes of the record, I just wanna
Clarify it.
clarify, that.
Thank you.
That, whether my understanding of your motion is correct. So your motion is, one, to adopt the, revised meeting schedule as proposed by staff with the change to the April meeting being removed and, with being removed as a regular meeting. And second, to approve, direction to staff to amend the rules of procedure section 1 to reflect the third Wednesday of the month as opposed to the second Wednesday, as recommended by staff. Is that correct?
That is correct. Thank you.
So at this time, you'll need a second to your motion.
seconded.
Okay. Board Secretary. Take a vote.
Board Member Hein,
Aye.
Board Member Warren,
I,
Vice Chair Parker,
Aye.
Chair Basili,
Aye.
motion carries 4-0.
Okay, at this time, do we have any board member comments or requests? Okay, then let's move on to the city attorney's reports and comments.
I have no further.
Okay, next meeting is scheduled on March 26th.
March 19, 2025.
Okay, thank you. Okay, it is time to adjourn our meeting. It's 7:42 or 7:24. Thank you.
Thank you. Evelyn, these are your binders, right?